What happens when a will is contested? Imagine spending months or even years planning your estate, only to find someone challenging your wishes after you're gone. When a will is contested, it means someone is questioning if the document is valid. This usually happens in the probate or surrogates court where the estate is being settled. The person contesting the will files a formal objection or petition, stating why they believe the will should not be accepted. Common reasons include claims that the person who made the will lacked the mental capacity to do so, was under undue influence, was tricked, or that the will was not properly signed or witnessed. Once the challenge is filed, the court notifies all interested parties, and the probate process can pause until the dispute is resolved. During this time, both sides gather evidence, which can include medical records, witness statements, previous versions of the will, or documents suggesting manipulation. This phase is called discovery, and it helps both sides prepare for the next step. After gathering evidence, a preliminary hearing might be held to see if there is enough to move forward. If the court finds the challenge has merit, the case proceeds to trial. At trial, both sides present evidence and call witnesses, including experts who can testify about the mental state of the person who made the will or whether the document was properly signed. The party contesting the will must prove its invalidity with clear and convincing evidence. If the court rules the will is invalid, it may accept an earlier valid will if one exists, or if not, the estate will be divided according to the laws of intestacy, which means distributing assets as if there was no will. If the will is upheld, the person who challenged it can choose to appeal the decision. Throughout this process, strict deadlines apply, often within a few months of the will being filed for probate. Missing these deadlines can mean losing the right to contest. Some wills include a no contest clause, which tries to discourage challenges by penalizing anyone who contests the will. However, the enforceability of these clauses varies depending on the jurisdiction. In elder law and estate law, will contests are sensitive because they often involve elderly or vulnerable individuals. It's essential to gather strong evidence and work with experienced estate attorneys to navigate these disputes properly. This helps ensure that the true wishes of the deceased are respected and that the process remains fair for everyone involved.